Which title do you prefer?
Whichever is comfortable for you.
Well, you throw it back every time, don't you? All right, Congresswoman Jordan. You said that, in your opinion, Robert Bork, as Solicitor General, violated regulations, if not law, was guilty of such violations. Now, if that was so, was the Senate wrong in confirming Robert Bork?
Senator, inasmuch as I've never been a member of this august body known as the United States Senate, I don't know whether you were wrong. You might have been.
Well, in your opinion, I'm asking, in your opinion.
I know what you are asking me, but what has to be understood is that the qualifications as set out by the ABA for its ranking or rating of persons who are nominated, those qualifications are totally different from what you as a senator must consider when you are looking at the nominee. And I would suggest then that the Senate and its collective wisdom, given its duty and obligation under the law and its advice and consent function, decided that it was the right thing to do. And I would not second guess it.
Well, but really, you're evading the question outrageously. First, you accuse Robert Bork of violating the law.
He did violate the law.
Well, very well then. In your opinion, should the Senate have refused confirmation?
And what I am saying to you is I am not going to second guess the Senate.
Well,
if the Senate wants to confirm a person who has blatantly violated the law, the said must have good reason for doing that.
Well, what possible reason could the Senate have for confirming someone unanimously if you claim he violated the law?
The Senate maybe felt that that was not a serious enough aberration for them to deny confirmation.
We really can't. You can't be serious. You can't be serious on that.
Of course I can be.
I have never seen you humorous, I must say, so maybe this is the first time, tongue-in-cheek. Very well. Now, how about the ABA? As you know, the ABA gave Robert Bork the highest qualification, highest possible rating, exceptionally well qualified, EWQ. Was the ABA wrong if Robert Bork was a criminal, as you suggest?
Senator Humphrey, I am not calling him a criminal.
Well, he violated.
He committed an illegal act.
Yes.
Every action of illegality does not a criminal make. Therefore, I do not call him a criminal. The ABA and its highest ranking, there is not a body in the land which, in my judgment, is incapable of being, from time to time, misguided.
Indeed, including the Supreme Court, as you know, and I'm sure you would admit in the case of some landmark decisions which have been reversed by one means or another, thank goodness. You're very good. Professor. I believe I'll call you Professor.
All right.
Well, let's talk about another point since I can't get anywhere, although I think I could get a lesser person really over a barrel. I can't get you over that barrel. You said something that disturbed me. You said that in reference to your own experience as one who suffered greatly from discrimination that, I've forgotten how you phrased it, but you said something about you personally saw the Supreme Court as the guardian of your rights. Is that a fair paraphrase?
Guardian of our liberties, guardian of the rights of the individual.
I don't quite agree with that. And I think here is the nub of this controversy. I view the Constitution, and not judges, as the guardian of our freedom, our rights, our liberty. It is not the opinion of judges, personal opinions, which is the guardian of our freedom, but a carefully crafted document.
Senator, you are right. This is the nub of the issue. Finally, you are right. As has been stated before, my faith in the Constitution is whole. It is complete. But the nub of the issue is this. Many people, particularly weak people, underprivileged, underrepresented, minority people, particularly the outs, have looked to the Supreme Court as the rescuer. The Supreme Court will throw out a lifeline when the legislators and the governors and everybody else refuses to do so. And there is, Senator, historical precedent for viewing the court that way. That precedent goes all the way back to an exchange between Thomas Jefferson and James Madison in their letters. Thomas Jefferson was all for the Bill of Rights being added to the Constitution. This was during the time of the ratification campaign. Thomas Jefferson was all for it. James Madison said no necessity for it. Thomas Jefferson said, well, let me try and explain it to you, Mr. Madison, why we need to put these rights in the Constitution. If we put them there, there will be courts to look at them and see that they are protected from intrusion by the government. Madison bought the argument and said, hooray, we'll do it because there will be independent judicial tribunals protecting the rights. That's where the correspondence starts. You can take it up further. There is a most obscure case that I know you have not seen in your deliberations here. It is the footnote in the Caroline Products case, v.U.S., a 1938 case, the footnote 4. It was so significant that there have been pages and pages of constitutional text written just about footnote 4. What did footnote 4 say? The judiciary has a task to protect minorities and people who need protection. And that is where that uniqueness of the judicial body comes forth. So, yes, I said the Supreme Court is the protector of the rights of the individual. I believe that. The independent tribunal, not subject to the whims of the electorate, not subject to the bias of the electorate, but above that bias, protecting our rights. That is the proper function of the court. And the reason why so many people reject the nomination of Judge Bork is that they do not want to see, we do not want to see an articulate, persuasive voice on the Supreme Court saying, that's not your function.